If your IP lives on scattered folders, unsigned contractor agreements, a spreadsheet that someone forgot to update years ago, you don't actually have an IP strategy. You have an IP liability. Here are the top 5 IP management strategies sophisticated companies use to manage, maintain, and keep track of their IP portfolio. Let's get into it. Strategy number 1, know what you own. Most companies cannot clearly answer these basic questions. What IP do we own? Who created it? Do we have assignments to that IP that was created? In order to make sure that you have answers to these questions, you need a centralized IP inventory. That includes patents, patent applications, trademarks, copyrights, trade secrets, domain names, key licenses with third parties, source code, product designs, brand names, proprietary data, anything of that sort. From a legal perspective, ownership is not automatic. Most companies think, I have an employee create this, I have an independent contractor that I hired or entered into agreement with who's doing stuff for me. Therefore, the things that they create, the developments they develop, the IP that they conceive, is then therefore going to be owned by the company. That is just simply not true most of the time. Independent contractors do not automatically assign IP to the companies they do work with. Additionally, things get even more complicated if you bring in another party. For instance, if you're doing joint development agreements, who owns that IP is not automatic by any nature. In this instance, the business risk is very straightforward. If you don't know who owns your IP, your competitors, your third parties who will potentially exploit it, they're not going to know either. Here's a key takeaway. Build an IP register where you can maintain and keep a running list of your IP and its ownership going forward, and make sure that you build HR processes involving dimension assignment agreements, processes involving onboarding independent contractors. Once you build it into your process of your company, it ends up being a lot easier with a lot less friction to get done the right way. Strategy number 2, align your IP processes with your business plans. IP should not be an academic exercise. It should frankly follow revenue and be in line with your business plans for your company. If you're building a business platform that you expect sort of rapid iteration of new products or technologies, trade secret protection may be the route to go. In that instance, you're going to want to align your IP strategy of maintaining those trade secrets, having non-disclosure agreements signed by employees, NDAs signed by third-party contractors, in line to make sure that those iterations, those Gen 1s, Gen 2s, ends up being protected by those trade secrets. In that situation where you expect sort of rapid growth, rapid expansion, rapid changes, patent protection may not be the route to go, even though you may have patentable technology. Keep that in mind in making sure that that type of IP, the way that you protect that technology, is in line with where you expect those products to end up going. On the flip side, if you're entering regulated markets, or markets in which things sort of move slower, in which you expect the life cycle of products to be longer rather than rapidly iterative, you may want to go down a different IP route. You may want to file patents. So for instance, if you're in industries like life sciences, medical devices, fintech, telecommunications, energy and aerospace, industries in which maybe you've got the FDA involved or other sort of regulatory government organizations, well then the lifespan of those products end up sort of naturally being longer, and so patent protection may make more sense just simply because it takes longer to get a patent than it is to make sure you keep a trade secret secret. If your products or technology are in a crowded space, if there's a lot of competitors that have very similar type products that do sort of the same things, maybe the brand is the crucial element of that product that distinguishes your products from your competitors. So things like early clearance, thoughtful selection of protectable trademarks, coordinated international filings, consistent enforcement of those marks against third parties. They all contribute to sort of preserving that IP that differentiates your products from your competitors. In this instance, weak brand protection, not protecting those marks, which is the thing that distinguishes those products, can lead to things like having to rebrand, running into infringement claims that you just don't want to, or erosion of sort of your place in the market. Across all 3 of those examples, the common theme is frankly misalignment of the IP strategy with the business strategy. I've seen many companies overinvest in certain type of IP protection that simply isn't needed or doesn't cover the thing that needs to be covered that makes their products different than their competitors. In both of those mistakes, you waste time and treasure, which none of us want. Strategy number 3, protect trade secrets deliberately. It's very common. I see a lot of companies try and think about trade secrets retroactively rather than trying to protect it prospectively. Trade secrets are often the most valuable IP a company can have, but they're the easiest to lose. So what does it mean to protect a trade secret prospectively? It means implementing things like reasonable document protection. It means limiting access to that trade secret, making sure that only the right people, the people who necessarily have to know that trade secret, are the ones who have access to it. It also means building trade secret protection into your HR policies. You want clear policies, employee training, regular employee training, confidentiality agreements with your employees, especially when they're onboarded because they're already signing a ton of documents anyways. You want to have structured onboarding and offboarding processes to make sure those employees are told about those trade secrets in the beginning and reminded about those policies when they exit the company. And it may also include vendor diligence. If you have third parties that are regularly handling those specific trade secrets, well, you want to make sure that they're doing the things that they should be doing to keep those things secret. One misconception that many folks have is that as long as I mark a document confidential, that it therefore means it's covered under trade secrets. Well, the problem is that courts don't look at the notation on a document and whether it's been stamped confidential. Rather, they look at how those documents and how those trade secrets are treated in practice in the business. Are there processes in place? Do they keep this secret? A marking on a document is not going to hold water alone. Another way to put this, maintaining a trade secret and being deliberate about it on the front end is a team sport. You're going to have your in-house counsel, you're going to have your HR, you're going to have your IT folks. All of those folks are part of that policy because they perform different aspects that make sure that you're doing all the things you need to be doing to keep that trade secret and maintain its confidentiality. The situation that I see most often is employee leaves a company and they disclose a trade secret or they disclose some information that they learned from their prior employer. And then their prior employer finds out about it. They know at that point, well, that's our trade secret. But if you ask that same employer on the front end, name your trade secrets, they may or may not be able to do that. So the action step that's just part of good IP housekeeping is maybe go through the exercise of identifying your top 5, your top 10, top 15 trade secrets and document those trade secrets and the protective measures to keep those secret. It's very, very easy to identify the thing that you don't want an ex-employee to disclose after the fact. Identify it beforehand and you'll be in a lot better position to enforce those trade secrets. Strategy number 4, clean up contracts before you need them. A good deal of good IP management hygiene is just simply contract management. Now, best practices in my mind are to build in your processes, to have your employees sign IP invention assignment agreements, to structure the agreements that you generally have with your independent contractors. The goal here is to have consistency across your suite of documents so that when you need to go back and maybe due diligence or refer to them, you know generally what are in those documents and what's covered. Now that I've told you that you need to keep all those documents consistent, a common mistake, frankly, is not adjusting those documents, not amending them to match the specific situation in instances in which they need to be bespoke. If you're independent contractors in a different jurisdiction, if you're doing cross-border agreements or deals, make sure that the template doesn't take over for the instance in which you need to tweak the IP language to make sure it does what it's supposed to do. So here's an action step. Periodically, perform an audit of your IP documents, of your NDAs, of your contractor agreements, especially after acquisitions, reorganizations, expansions into new jurisdictions. Don't let the template become something that can't be changed at all. Strategy number 5, plan for enforcement and defense early. So IP strategy is not just about filing, it's also about leverage. You should understand how you would respond if a competitor infringes your technology, or conversely, you should understand your exposure if you received a demand letter from a third party. Do you have freedom to operate analysis for key products? Do you understand sort of where your risks lie with regard to your key products, whether or not there are third parties that have IP on your products and the IP that you have protecting those products. It also means monitoring your competitors. Things like having a budget to handle disputes and things of that nature when it involves IP. That can be part of the business plan. Again, waiting until litigation is filed is the last time you want to be thinking about this. You want to be thinking about those litigation risks early on the front end so that they're part of the plan. From a business perspective, enforcement really should be a strategic thing. Just because somebody infringes your IP, just because they infringe your patents, doesn't mean that you have to send out a demand letter or a cease and desist letter every single time. There may be instances in which you want to enforce it quietly. Maybe they're a business partner. Maybe they're a third party that you compete with, but also they compete with you, so you've got IP on both sides of the fence that maybe you don't want to get into a war with. And so maybe a cross license here or there makes sense. These are the type of things that you should be thinking about rather than just simply jump into, I need to sue them because they're infringing. Overall, the thing we're trying to do is make it such that the decisions we make are far more effective on the front end than they are in the back end. You end up in a better place if you're prospective rather than reactive. Those are the top 5 IP management strategies that help sophisticated companies maintain, protect, and enforce their IP. Thanks for watching. Catch you next time.